Are we live? Is this thing on? Had to brush some dust off of it for this Fairfield Harbour podcast. Um, it's just after midnight, but you make time for the things you want to make time for, right? And I can tell you're going to hear me pouring wine because it's after midnight. So we're going to have drinks as we do this. But I've missed you guys. I've done a couple of other podcasts. I started another one called Home and Hustle. It's available everywhere that you get podcasts. And so I've been out and about. I've done some things for a local Taekwondo dojang here in New Bern. And yeah, I have not been updating the Fairfield Harbour podcast for a few reasons. One, just got kind of trite, right? Like, I feel like I got into such a negative headspace there for a while, um, amongst a couple of other reasons. But I had to come back for today. And by today, I mean yesterday. So, yesterday, we got an email that 74 community members sued the community. So we're going to, on this podcast, we are going to read through the letter that came out from the president of our Property Owners Association. And then we are going to get into and read through the lawsuit itself. There are multiple attachments. The lawsuit is 92 pages. We are not going to do all of that today. At some point, I have to take a nap. But again, this is important. I live here. You live here. If you're watching this and you live or even don't live in full time, but own a property in Fairfield Harbour, it's important that we keep a pulse on what's happening here, both the ridiculous as well as the well-meaning and wonderful. So let's get into it. I am going to share my screen, I think. Look at that. Oh, I did. So, I had created like this little Fairfield Harbour podcast logo back when I first started this podcast in 2023. And it had like all the blues to kind of match what we were doing here in the neighborhood. And then kind of all the little banners, again, keeping with the aesthetics here that matched the signs out front. Well, we've since gone digital and everything glows in the dark. And it is, in my humble opinion, atrocious. So I have changed the logo. You will see it's got the river. It's got the what I perceive as the tree line where we look out across Northwest Creek. There is a big peninsula that comes down that is part of the game lands. And that is what I perceive here in our new little logo, little podcast mic filled in with the night sky and the river, the creek going down. Oh, and we just sponsored Nick Walters owns Walters Jiu-Jitsu here in New Bern, North Carolina. Well, I guess the school is over in James City, but that's where my husband and son do jiu-jitsu. They just went to Portugal to compete. We sponsored them as part of the stronger our schools are and the stronger the programs are in New Bern that support our kids and help raise them up, the better our kids are, the better our future, our collective future is, right? So we felt it was really important to sponsor financially Nick to go to Portugal and compete, bring back everything that he learned. And he did so well, but they brought me back a bottle of wine. And that's what I opened tonight. I can't tell you what the name Douro. I don't know. Let's see. Can we see that? I'm not a very good. Okay. Anyway, it's from Portugal. And so that's what we're having tonight. I haven't even had a first sip. Let's do that. That's good. It's almost like a cab and a Pinot Noir got married and had a baby. It's red. It's bold, not as dry as a cab. Oh, that's good. This is going to be a fun podcast, y'all. All right, so let's get into this letter. This came out, you can see at 4:36 p.m. on February the 12th. It came out from the Fairfield Harbour Property Owners Association to everybody that gets their communications. And it is subject line: community group sues the community. A letter from your board president. Fairfield Harbour Property Owners Association Bulletin. All right. Got to figure out how this works again. Okay. I just have to stop and say, because we just had the budget meeting, like a week or so ago. And I did volunteer to help live stream that meeting, right? Like, I have a platform to be able to do that. I have wireless mics that can go around and people can talk and we can actually hear what folks are saying, the back and forth. It went really, really well. The mechanics of the meeting, the recording of the meeting. The other thing that I tried to shore up, if the Fairfield Harbour Board will take it as such, was in the past, we've had a lot of different modalities to collect and share information on behalf of the board. And there are multiple Facebook channels: Fairfield Harbour, Fairfield Harbour NB, Fairfield Harbour, North Carolina. They're all run and kind of owned, if you will, by individual community members here. And when it got time for me to go record the meeting, Jennifer in our office got me in touch with who had recorded the last meeting or whatever, whether it was a candidate's night or something. Anyway, he's got the stuff. He will give you the credentials. He can't be at the meeting, but if you can record it. So whenever I talked with him, he was like, well, you can set up your own YouTube channel and record it. Well, yeah, I know how to do that. Done that. Check. But that's not what I'm trying to get at. I think the board needs to have a singular point of communication, right, to the community. So what I did was I set up an email address that is just for the board. I set up a YouTube channel that is just for the board. I sent Jennifer and a member of the board the credentials to log in. I was like, after I've done recording this budget meeting, feel free to change the username and password. So I can't get in, but this is what I did in order to share this. This is the whole act, like everything was board centric, right? This is how you can get information out. Happy to help in any way moving forward, but we need a singular source of truth for information, because a lot of the dissension, misinformation, varying degrees of how important things are. We have a bajillion Facebook pages. There are Instagram pages. There are YouTube channels. There is a singular email that goes out. People are overwhelmed. We get alert fatigue on email. I get so much email. I do not check it unless something is like, open this immediately, or someone has messaged me to say, hey, I'm going to be sending you something. Be on the lookout for it. I get too much email. So email is not my primary point of communication. But I will say that when you have community members, whether they're on the board or not, and they all individually run and maintain separate modalities for getting messages out, the intent, the tone, the look and feel of the communications, the people that are subscribed to those pages or channels, as that varies from place to place, as does the message, the engagement. And so I do feel like as we look into 2025 and all of the changes that are on the horizon for us in Fairfield Harbour, I feel like a singular source of truth that the board owns, uses, is the way for them to go, rather than putting that in the hands of individual community members that may or may not agree with what the board is doing, right? So be that as it may, that's what I did for the budget meeting. I am hoping, fingers crossed, that someone on the board or at the office, whether it's Troon or whomever, takes that stuff that I created. It's one video right now, but it could be so much more. And even if we could take older content and put it out there, candidates nights, budget meetings, whatever, our annual meeting, put it all out there in a singular place. All of the things that we've done about community, the concerts and all that stuff, the parades at the holidays, put it all out there. Make it a singular place where people can go for information about our community. We want this place to be a place where people want to be. And I truly feel like the death knell of morale here has been just the lack of a singular mouthpiece for our board. So be that as it may, they can fix it if someone would just step in and do it. So this email came out from the president of our board, whether you like him or not. It is with a heavy heart. My face is going to have subtitles. I'm sorry. I can't help it. I've read this letter. I have not read the lawsuit. We're going to do that together on this podcast, but my face is likely going to have subtitles. I can't stop it because I'm basically Dorothy from Golden Girls. It is with a heavy heart I must inform the residents of our wonderful community that the group who announced to us last year that they intended to sue Fairfield Harbour has finally taken that action. This is called We Told You So. During my term as president of the Property Owners Association, the board of directors has done everything within its power to heal the community from a divide that started before most of this current board were installed. I can and will attest that your board members have worked tirelessly to address all issues within their power. POA meetings have been open to the public. Whenever possible, contracts and documents have been made available for viewing. All of the board members expressed that they have an open door policy to answer any questions or to discuss problems they may have. The Community Advisory Committee was formed to help find ways to address issues before they became problems and bring them to the board for action. In short, nothing has appeased this unhappy group. In reading their complaint, you will notice that the main thing they want to control is the board of directors. That is, remove the particular individuals they don't like so they can vote in those they prefer. This suit will cost the community tens of thousands or more dollars than we already experienced a year ago when they chose to remove 2 directors who were up for re-election only a month later. 2 of the 4 directors they wish to remove currently have terms expiring in a couple of months. I am one of those with an expiring term, and I do not plan to run again. Attached is a copy of the entire suit filed by 74 individuals. The principal complaint is that the board's vote to increase the required percentage of eligible property owners, association members, required to remove board members without cause, was invalid. It was the decision of the board that allowing less than 30% of the total eligible property owners to vote out the entire board at any time they wished was not good for the community. There are elections for board members every year, and they can elect whomever they choose if they have the votes. At the time this vote was taken, Hope Carmichael was included in the meeting via Zoom call and advised the board that the vote was legal and proper. Those suing claimed that 5 days' notice for the vote was not given and thus the vote was illegal. Below is the actual statute that responds to that claim. We're going to talk a lot in this general statute about North Carolina General Statute 55A. That is the North Carolina General Statute that governs what homeowners associations or property owners associations can do in the state of North Carolina. I will say personally, it is vague. I do not think there are enough controls in place. Not that I want the government in every piece of my business, but at the same time, we get into issues when the state government puts power in the hands of a few when our community is over 2,800 properties. And in my opinion, the right modalities are not taken, the right due diligence is not taken to understand what your community wants, to take quick actions such that that community is heard at that point in time. I have heard since we moved here about 4 years ago, hey, we voted on this back in 2018. Well, then why is it 2025? And we're just starting to do this. Like, the whole community is different now than it was then. So I just, I think the transparency and communication, the swiftness with which we take actions on votes that we make and community feedback that we seek, those are kind of the pivotal things that have led to a lot of this. But again, North Carolina General Statute 55A is where well, that's really our only recourse at this point, right? But this waiver of notice, it's 55A-8-23. A. A director may waive any notice required by this chapter, the Articles of Incorporation, or bylaws before or after the date and time stated in the notice, which, again, super vague. Hey, you can take notice. You can waive any notice required by this chapter before or after the date and time stated in the notice. No amount of time before, no amount of time after. It's just kind of big, broad brush strokes, right? So just keep that in mind. There's not a lot of recourse whenever you go to vague legislation. That's why reform exists, right? But except as provided by subsection B, which we'll read here in a second, of this section, the waiver shall be in writing, signed by the director entitled to the notice, and filed with the minutes or corporate records. B, a director's attendance at or participation in a meeting waives any required notice to him of the meeting unless the director at the beginning of the meeting or promptly upon his or her arrival, objects to holding the meeting or transacting business at the meeting and does not thereafter vote for or assent to action taken at the meeting. Did you understand that? Right? Because we write all of our statutes and things where the common man, woman needs to be able to read and understand at a third grade reading level is what we're supposed to be doing. But a director's attendance at or participation in a meeting waives any required notice. So if you show up to the meeting, you're waiving the need for having gotten a required notice. They're assuming you knew to be there, right? Unless the director at the beginning of the meeting or promptly upon their arrival objects to holding the meeting or transacting business at the meeting, does not thereafter vote or assent to action being taken at the meeting. So they have to verbalize, hey, I don't agree with this meeting or taking any action as part of it as soon as they get there, right? God, that is good wine. I'm going to have to find out where to get some of that. All of the board of directors were in attendance at this meeting. No objection was made objecting to the meeting or having this vote. All members voted, and the motion to change the required percentage passed. Our attorney, who is a partner in one of the oldest POA law firms in North Carolina, out of Raleigh, North Carolina, our state capital. Sorry, that was in parentheses in my mind. In North Carolina, helped the state of North Carolina write many of the laws, was present via Zoom for the vote and indicated that everything was proper. She intends to represent the POA in this matter. So we have an attorney that represents our community based in the state capital of North Carolina, Raleigh, who helped write a lot of the laws that govern and dictate what homeowners and property owners associations can do She is representing Fairfield Harbour, the community, as part of this lawsuit. Take that for what it's worth. I will note that going through this process is expensive and, to my view, completely unnecessary, as we already have upcoming elections for 2 and the 4 board members they want removed. So we have upcoming elections for 2 of the 4 board members they want removed. The remaining 2 have 1 more year before their term expires. You will note that 74 property owners signed the complaint out of over 2,800 members. I am sorry to have to inform you of this development. Your current board of directors have tried to bring this community back together, and this lawsuit, brought by 3% of our property owners, brings on another sad chapter. If you are selling your home, please note that North Carolina law requires any litigation pending against the POA to be disclosed, and you should feel free to share this summary with your real estate agent as he or she assists you in filling out those forms, in addition to a copy of the lawsuit. Again, they attached the document, the lawsuit, for our review, signed by Les Pendleton, Fairfield Harbour Property Owners Association Board President. Okay. Now, I'm going to switch us over to the lawsuit itself. So I will say that there are several pages in this lawsuit that I did not redact this page. I mean, this is public knowledge, right? This was electronically filed on February the 9th, 2025 by the clerk of court here in Craven County. So again, it's 92 pages. But I will say that, let me just look at something really quick. I will say that there's a section in here that includes everyone's individual addresses. Again, you can go find this on your own, but I am not doxing anybody as part of this. So I did take the time to go through and redact all of the physical addresses of these people. Okay. So these are the 74 names. It is continued on to another page. They are the plaintiffs, and the defendant is going to be Fairfield Harbour Property Owners Association. Now, I have to just stop and say that I listen, excuse me, I listen to a lot of legal commentary on YouTube. I love LawTube, okay? I happen to be part of the chat, I happen to be a part of the Law Nerds. I am in it. It is in the background all the time. So I am going to read through this, and I am feeling very much like some of the people that I just feel like I know already. And I'm going to reach out to some of them and see if I can have them on to talk to me about this, because they are lawyers with legal experience. They are not in the state of North Carolina. So there's no no conflict of interest there. But I want to hear from their perspective what this looks like to them from both a community member's point of view, as well as someone who does not always agree with our property owners association. So I am going to reach out and ask if I can get them on, because that would be the highlights of my 2025. All right. But I'm going to have a moment here because I'm going to channel them. All right. Now come all plaintiffs by and through undersigned counsel and complaining of defendant, Fairfield Harbour Property Owners Association, Inc., and do hereby allege and say the following. Introductory. And again, as my friend, she's not really my friend in real life, but Emily D. Baker, she is a legal commentator on YouTube. She says lawsuits, allegations, and shade. Okay. And when I read this first introductory paragraph and was like, oh, no, stop, we're going to read this all together, it brings some heat. So I'm excited to go through this. This is allegations and shade, right? Everything here is alleged until we get through the process, right? This declaratory judgment action and motion for a preliminary injunction arises from the unlawful and defensive actions of the Board of Directors of Fairfield Harbour Property Owners Association. The Fairfield Harbour the Fairfield Harbour subdivision is a 2,800 plus lot planned community in Craven County, North Carolina. In spring 2024, a majority of the eligible property owning members of Fairfield Harbour Property Owners Association successfully voted to remove 2 members of the board of directors. On June 28th, 2024, we got to keep these dates and timelines in line. On June 28, 2024, in an unveiled effort to protect themselves from meeting the same fate, a majority of the remaining directors of the board unlawfully purported to hold a vote amongst themselves to change the association's bylaws. Specifically, the board voted to require a supermajority of 67% of members to remove a director, when the existing requirement for removal was a majority of the members. This action not only violated the express language of the association's bylaws, it was also a clear and unabashed violation of North Carolina General Statute Section 55A-8-08, which limits and caps the votes required to remove a director to that which, in quotes, would be sufficient to elect the director at a meeting to elect directors. Not to be redundant. Even if an increase of the vote required for director removal was permissible under the bylaws or applicable law, such an amendment could have only been approved by an affirmative vote of the association members under North Carolina General Statute Section 55A-7-23, voting requirements, and 47F-3-103B, executive board members and officers. Further, the purported amendment of the bylaws must have been attempted either through North Carolina General Statute Section 55A-10-20 amendment by directors, or North Carolina General Statute Section 55A-10-21 amendment by directors and members, if North Carolina General Statute Section 55A-10-20. Are we bored yet? Okay. Was the statute purportedly employed, the amendment fails because the defendant failed to comply with the notice required and failed to recognize that the corporation has members entitled to vote thereon. If North Carolina General Statute Section 55A-10-21 was the statute purportedly employed, the amendment fails because members were not involved in the purported amendment process. Lastly, even if the board had possessed authority to amend the bylaws to require a supermajority vote for the director removal, their action was invalid due to lack of proper notice of the vote, which was not waived. In September of 2024, so that was in June, that this meeting and vote happened where they got a supermajority in place. So that was in June, the end of June. So 2-ish months, almost 3 months later, we're in September. Okay. In September of 2024, another members' vote was taken to remove 4 directors or any of their replacements for the remaining portions of any term without cause, the results of which was a majority in favor of removal, but which the board of directors deemed a failure due to the lack of a supermajority vote. Accordingly, plaintiffs now seek I should have looked these words up, inter alia. Hold 1 second, please. I don't know what these things mean. Inter alia is the Latin phrase that means among other things. Okay. Where was I? Board lack of super. Okay. So according to the plaintiffs, now seek inter alia, among other things, right? Inter alia, among other things, declaratory relief affirming that the aforementioned majority vote of 52.31% to remove the 4 directors was valid and effectual. The conduct of the board of directors in amending the bylaws was ultra vires. Okay. I know it's Latin. Ultra vires or vires. Beyond the powers. Okay. We're going to have one more to look up. So beyond the excuse me. To remove the 4 directors was valid and effectual. The conduct of the board of directors in amending the bylaws was ultra vires or vires, meaning beyond the powers, and void ab initio. Void ab initio. Getting a little ASMR here. Void from the beginning. We're learning something new here. We got language. We've got allegations and shade. We've got a new logo. I painted my office since we were here last, but let's stay on track, Emily. ADHD. So let's start the sentence over. According to the plaintiffs, which are the 74 people suing the board or the Property Owners Association, plaintiffs now seek inter alia, among other things, declaratory relief affirming that the aforementioned majority vote of 52.31% to remove the 4 directors was valid and effectual. The conduct of the board directors in amending the bylaws was ultra vires, beyond the powers, and void ab initio, void from the beginning. So it was beyond their power and void from the beginning. And declaring that the voting requirements for removal of a director must comport with all provisions of North Carolina General Statute Section 55A. That's the whole kit and caboodle, including but not limited to 55A-8-08 Section C. Plaintiffs further seek to enjoin the board of directors from taking any action based on their purportedly amended bylaws and to enjoin the 4 removed directors or their replacements from remaining on the board or taking any action as directors. Plaintiffs seek immediate removal of the 4 directors, their replacements that were voted against in September 2024, and to reinstate the bylaws as they existed prior to the board's unlawful vote on June 28th of 2024. Here's where we get into the parties, the jurisdiction, and the venue, where we're going to hear this trial, right? Fairfield Harbour subdivision has shown on maps recorded within the Craven County Register of Deeds incorporated herein by reference as a planned community with over 2,800 lots in Craven County. At all times, material hereto, plaintiffs owned and continue to own real property within the Fairfield Harbour subdivision as listed below. And again, it goes through in 4 through 70. So all of the people that you saw in the plaintiffs listed on page 1 of this lawsuit, and we are going to keep going, but I just redacted, meaning removed, all of the physical property addresses. You won't get that here. We're not doing that. You can get it on your own if you'd like. So I took those out. Okay. As owners of real property within the Fairfield Harbour subdivision, all plaintiffs were and are members of Fairfield Harbour Property Owners Association, Inc., as of the date of the unlawful acts complained of herein, and being the improper and ultra vires, beyond the powers. To keep looking that up. That's just so outside of my normal. As of the date of the unlawful acts complained of herein, that being of improper and beyond the powers amended of the association's bylaws by vote of the board of directors of the association as further described below. The Master Declaration of Fairfield Harbour dated October 23rd, 1979. So that is 45 years old, almost 46 years old. Okay, for reference. Sets forth certain provisions applicable to properties in Fairfield Harbour subdivision and declares that property owners shall become members of Fairfield Harbour Property Owners Association. See the Master Declarations of Fairfield Harbour, Exhibit 1, page 7, attached. I'm not, again, going to get into all the exhibits tonight. There are multiples, I think, more than 9. At least 9, if not more than 9. We're not going to get through all of those this evening, but we're going to get through the actual lawsuit itself. The Master Declaration of Fairfield Harbour describes the Fairfield Harbour subdivision in part as certain properties in Number 2 Township, Craven County, North Carolina, a portion of which properties were conveyed to Fairfield Harbour, Inc. by deed from Treasure Lake of North Carolina, dated December 9, 1977, and recorded in Book 901, page 504, in the Office of Register of Deeds of Craven County, and a portion of the aforementioned properties, together with certain properties adjacent or contiguous to, thereto, or in the general vicinity thereof, comprise a development known as Fairfield Harbour. See the Master Declaration of Fairfield Harbour, Exhibit 1, page 1. Articles of Amendment to the Reinstated Charter of Fairfield Harbour Property Owners Association, Inc., filed October 12, 1983, describe the Fairfield Harbour development as the same may now or hereafter be shown on the maps and deeds thereof, recorded from time to time, including without limitation the property shown on the maps of Treasure Cove subdivision, that property identified in those deeds recorded in Book 901 at page 504, Book 930 at page 798, and Book 964 at page 936 of the Craven County Registry, and all the property contiguous to or in the general vicinity of the foregoing property. See Articles of Amendment, Exhibit 2, attached. Defendant, Fairfield Harbour Properties Owners Association, a nonprofit corporation organized under the laws of the state of North Carolina, is the property owners association which is charged with the management of the development known as Fairfield Harbour, located in Craven County, North Carolina. See the Declaration of Unit Ownership, Exhibit 3, page 1. Defendant Fairfield Harbour Property Owner Association, hereinafter referred to as the association, is a nonprofit corporation incorporated and existing under the laws of North Carolina, with its principal place of business and principal business office being located in Craven County, North Carolina. The court has jurisdiction over the subject matter of this action as well as over the parties hereto. Venue is proper in the Superior Court of Craven County, North Carolina. Here we go. These are the statements of fact. At the time of the actions complained of herein, the association was governed by the 2020 amended and restated bylaws of the Fairfield Harbour Property Owners Association, hereinafter referred to as the bylaws. See Bylaws, Exhibit 4, attached. The bylaws of the association call for a 7-member board of directors, each of whom were to be elected by a plurality of votes of the members at the annual meeting. Exhibit 4, pages 11 and 12. Before and in 2024, the above captioned plaintiffs held grave concerns about certain actions and financial decisions by the board of directors of the associations. These concerns prompted a petition for a member vote of the removal of 2 members of the board of directors. On or about May 13, 2024, the results were announced, that being that the majority of the association members were in favor of removal of the 2 directors. So again, in like April, May, we had a couple weeks to vote, right, to get our votes in, especially the paper votes for those folks that own property in Fairfield Harbour but may not live here full time or at all. They have rental properties here. So there were electronic votes, there were some paper ballots that were coming in, right? So we have a period of time to vote. And when we got this, I think it was in April, we had them do, and then in May they did all the collecting and the results were, and then these 2 board members by the 53.21, or I may have some of those numbers mixed up, but anyway, it was a majority vote voted for the removal of those 2 board of director members. Okay. In number 88, in a heavy-handed and unlawful reaction to this member vote, the remaining board of directors attempted to avoid a similar fate, which was coming, which is the basis of the instant litigation. On June 28, 2024, the board of directors held a meeting. The minutes of this meeting are attached in Exhibit 5. At no time prior to the meeting was noticed that a motion to amend the bylaws would be made, and this item was not listed on the meeting's agenda. However, after the meeting began and after new officers were elected, Board Member Pendleton, here we go, asked if it would be possible to amend the bylaws so that a petition for removal of board members would have to have a cause and a supermajority. So before, with or without cause, right? By the number of votes that would be eligible to be elected, right? So now we're asking for a supermajority and cause, okay? Director Pendleton made a motion to add a bylaw to change the end of the agenda, seconded by Vice President Peppercorn. I don't know how to say that last name, sorry. It was approved by President Albertini, Vice President Peppercorn, Directors Brody, McLam, and Pendleton, and was opposed by Directors Barajas and Moore. Keep in mind that Barajas and Moore were the two new directors that were voted in prior to Les Pendleton bringing up that he wanted to add this to the agenda for that day to be voted on that day. So the two members of the board that voted against it were the two brand new members voted in same day. Okay? Motion passed by a majority vote. Director Pendleton, so the other 1, 2, 3, 4, 5, the other 5 voted for making this supermajority with cause. They are the 5 that people are not happy with, right? Director Pendleton made a motion to amend the bylaws stating that any vote for removal of any member of the Fairfield Harbour Property Owners Association Board, including current members, will require 67% of POA members who are eligible to vote according to the POA bylaws in effect at the time of said recall ballot is distributed for voting. President Albertini made a second, and it was approved by Albertini, Peppercorn, and Directors Brody, McLam, and Pendleton. It was opposed by Directors Barajas and Moore. Again, the two brand new members that day. Motion was approved by a majority vote. Then there's the bylaws, section 9, paragraph A, which is an exhibit. So Attorney Carmichael will send Secretary Miller the exact wording needed for the amendment. That is in Exhibit 5, pages 2 and 5. Resolution 2024-03 of the Board of Directors of Fairfield Harbour Property Owners Association was later entered, stating as follows. A vote for removal of a director may be called by the Board of Directors or by petition of the members for special meeting as otherwise provided in these bylaws, provided, however, that the vote required for removal of a sitting director who has been duly elected or appointed pursuant to these bylaws shall be not less than 67% of the eligible vote of the POA membership. See Resolution 2024-03, Exhibit 6. Okay, so let's just read that one more time because I kind of messed it up. A vote for removal of a director may be called by the Board of Directors or by petition of the members for special meeting as otherwise provided in these bylaws. Provided, however, that the vote required for removal of a sitting director who has been duly elected or appointed pursuant to these bylaws shall not be less than 67% of the eligible votes of the POA membership. Notice it doesn't have the cause, right? We talked about in the meeting that we wanted it with cause and we wanted the supermajority. Our attorney was going to send our attorney who helps write laws for North Carolina as it relates to property owners associations, said, I will send you the exact wording that you need to put in the bylaws. And we have the supermajority in there, but not the with cause. Okay? The board's actions set forth were unauthorized, unlawful, and invalid. Not only, I'm sorry, I just have to take a second. Not only did this purported bylaw change by the board of directors violate the wording of the bylaws themselves, North Carolina General Statute Section 55A-08, 8-08, and other sections of Chapter 55A and or 47F, it was effectuated without proper notice, which was not waived. Even if such a change to the bylaws, the purpose of which was to increase or decrease the vote required for any member action, was authorized by law, only the association members could have voted for and approved such a change. In or around August 2024, some plaintiffs herein submitted a petition for a special meeting for the purposes of removing 4 of the then current directors, Les Pendleton, Gail Albertini, Robert Brody, and David Pfeffercorn, of any of their replacements for the remaining portions of any term without cause. On September 27, 2024, the results of the ballot for such removal were as follows. The removal of the 4 members of the board of directors, so 4 removal, we are ready to get them gone, was 52.31%. Against removal of those 4 board of director members was 47.69%. There was a ballot memo, it's Exhibit 7 attached. Under their purported unlawful bylaws requiring a 67% supermajority vote, those board of directors then declared that the recall measure to remove the directors failed. Plaintiffs have been harmed by the board's declaration that the measure failed and by allowing the directors and or their replacements whom a majority of members voted to remove to remain on the board. The violations by the defendant of the bylaws, which is a valid contract between plaintiffs and the association, and of multiple North Carolina general statutes are set forth below. The board's actions violated the express terms of its bylaws and the North Carolina Nonprofit Corporation Act. In Article 4, Official Meetings of Members, at Section 6 of the bylaws, it is specified that association members elect board of directors through a plurality vote, with the exception of the declarations, DOR. Declarations of restrictions, amendment 67% affirmative, and the election of directors of the Fairfield Harbour Property Owners Association plurality vote. Any meeting of the members of the association at which a quorum is present, or at any vote by mail-in ballot without a meeting where a quorum has participated, a vote of a majority of those votes cast shall be necessary for the adoption of any matter voted upon by the members. Okay, so with the exception of the DOR amendments, the 67% affirmative, and the election of directors of the Fairfield Harbour Property Owners Association plurality vote, any meeting of the members of the association at which a quorum is present, or any vote by mail-in ballot without a meeting where a quorum has participated, the vote of a majority of those votes cast shall be necessary for the adoption of any matter voted upon by the members. In Article 5, Removal of the Directors, at Section 9 of the bylaws, it's specified that removal of directors is governed by the North Carolina General Statute, Section 55A-8-08. Pursuant to North Carolina General Statute 55A-8-08 and Article 4, Section 4B of these bylaws, directors may be removed from office with or without cause at a special meeting of the members of the association called specifically for such a purpose. Specifically for such a purpose. It's not like and while we're here, can we also do this? It's specific for a purpose. Section 55A-8-08 of the North Carolina Nonprofit Corporation Act, removal of directors elected by members or directors, states without allowance of the bylaws or other governing documents to specify otherwise. Okay, so without the allowance of the bylaws or other governing documents specifying otherwise, the members may remove one or more directors elected by them with or without cause unless the articles of incorporation provide that the directors may be removed only for cause. And we didn't amend our bylaws to include, it was just the supermajority. Cause was not included. If a director is elected by a class, chapter, or other organizational unit, or by region or other geographic grouping, the director may be removed only by that class, chapter, unit, or grouping, except as provided in subsection 1 of this section. A director may be removed under subsection A or B of this section only if the number of votes cast to remove the director would be sufficient to elect the director at the meeting to elect directors. Okay? Let's read that again. Except as provided in subsection I or 1 of this section, a director may be removed under subsection A or B of this section only if the number of votes cast to remove the director would be sufficient to elect the director at the meeting or at a meeting to elect directors. In addition, North Carolina General Statute Section 55A-7-23, the voting requirements, states that unless this chapter, the Articles of Incorporation, or the bylaws require a greater vote or voting by class, if a quorum is present, the affirmative vote of a majority of the votes cast is the act of the members. An amendment to the Articles of Incorporation or bylaws on which members are entitled to vote, the purpose of which is to increase or decrease the vote required for any member action, shall be approved by the members entitled to vote on that action by a vote that would be sufficient to take the action before the amendment. Thus, because the voting required for the removal of a director is specifically governed by Section 55A-8-08, a fact that this is also specifically acknowledged by the bylaws themselves, the voting requirements set forth within 55A-8-08C cannot be changed. Alternatively, if this court finds that such an amendment to increase the vote required for director removal was permissible by contract, the bylaws, or statute, then the plaintiffs asserts that such amendment could only be effectuated by a vote of the members under 55A-7-23. I mean, that's how I read it. That the directors can't do it by themselves. They have to have, right, the plurality vote of the members. Defendant's response that Article 9 of its bylaws, as they existed at the time of the vote, allowed the board of directors the unfettered right to amend any and all bylaws, fails and as inconsistent with the bylaws themselves, the applicable North Carolina general statutes cited above and below, laws of contract interpretation, North Carolina General Statute 55A-2-06 bylaws states that the bylaws of a corporation may contain any provision for regulating and managing the affairs of the corporation that is not inconsistent with law or the Articles of Incorporation. At the time of the Board of Directors' unlawful amendment of the bylaws, Article 9 of the bylaws stated in its entirety, these bylaws may be amended by the affirmative vote of 5 of the 7 directors of the board. Article 9 is specifically limited by Section 55A-8-08 removal of directors elected by members or directors, which does not contain a clause allowing an exception to its applicability as it does, for instance, with respect to limiting removal of a director for cause only if articles of incorporation so provide, and 2, expressly states that a director may be removed under subsection A or B of this section only if the number of votes cast to remove the director would be sufficient to elect the director at a meeting to elect directors. I mean, boldface and underscore added, so it's not that way in real life, okay? We're emphasizing it. Thus, the purported amendment was inconsistent with law, namely Section 55A-8-08. By way of further explanation, an amendment to the bylaws must be consistent with Section 55A-8-08C, which states a condition of director removal must be that the number of votes cast to remove the director would be sufficient to elect the director at a meeting to elect directors. As per the bylaws, the number of votes sufficient to elect a director is plurality. Therefore, the number of votes necessary to remove a director cannot be less than plurality. Right? In my mind, I'm playing Legally Blonde. Like, it's hard. Therefore, the number of votes necessary to remove a director cannot be less than a plurality. The 67% provision purportedly adopted by the board violates this provision. The number of votes sufficient to elect a director by plurality is a majority only, at most. For example, if 2 candidates were running and there were 100 eligible votes, then the number of votes sufficient to ensure a win for a particular candidate is 51, which is a majority. If 3 candidates were running, then the number of votes sufficient to ensure a win for a particular candidate is 34 out of 100. Under the same scenario, if 4 candidates were running, then the votes needed to ensure a win is 26. In sum, the number of votes sufficient to be elected as a director is, at most, a majority. Therefore, the attempt by the board of directors to change its requirement to 67%, a supermajority, to remove a board of director, not to elect them, but to just remove them, violates North Carolina General Statute Section 55A-8-08 and the bylaws. Again, these are statements of fact. I have heard nothing wrong yet. Alternatively, if the bylaws could in fact be amended to contravene Section 55A-8-08, which is denied, it is submitted that such amendment could only be effectuated by a successful vote of the members, not the board of directors, but the members pursuant to North Carolina General Statute Section 55A-7-23 voting requirements and 55A-10-21 amendment by directors and members. By virtue of being owners of the subdivision, each owner is a member. The corporation has members. The members are entitled to a vote on amendments to the bylaws. The bylaws purport to allow the directors to amend bylaws, but do not preclude amendments from the bylaws by members and expressly allow members to vote on matters. Members are entitled to vote on amendment to the bylaws, which is to increase or decrease the vote required for any member action. The vote by members that was sufficient to amend the bylaws prior to the amendment in question, in this case, was a majority. 53.21, if I don't have my numbers mixed up. The board's action also violated the Planned Community Act as made applicable through its master declaration and bylaws. Plaintiffs further assert that defendant was submitted to the provisions of the Unit Ownership Act or to any similar act providing for condominium or unit ownership of property which includes the Planned Community Act, North Carolina General Statute, Section 47F, which mandates that removal of directors can be accomplished through a majority of members. North Carolina General Statute 47F-3-103B, Executive Board members and officers. The Master Declarations of Fairfield Harbour state that for each property subject to the provisions of this Master Declaration, the provisions to which property is subjected shall be applicable to each subdivided lot therein, each unit in a tract of land submitted to the provisions of the Unit Ownership Act, Chapter 47A of the North Carolina General Statutes, or to any similar act providing a condominium or unit ownership of property. Article 2 of the Master Declaration of Fairfield Harbour Property Owners Association states in relevant part, every person upon acquiring title, legal or equitable, to any property in Fairfield Harbour subjected to the provisions hereof shall become a member of the Fairfield Harbour Properties Owners Association, Inc., a North Carolina nonprofit corporation, hereinafter referred to as the association. In Article 10 of the Master Declaration, grantee's acceptance states in relevant part, the grantee of any property subject to the provision hereof by acceptance of a deed conveying title shall accept such deed or contract upon and subject to each and every provision hereof applicable to such property and the agreements herein contained, and to keep, observe, comply with, and perform such provisions. This is in Exhibit 1, page 19. The bylaws adopt and invoke North Carolina General Statute Section 47F no less than 6 times in the document. Powers. The board shall exercise the enumerated powers in North Carolina General Statute 47F and 55A. Perform any and all other acts for which the authority has been granted herein under North Carolina General Statute 47F and or 55A. Pursuant to North Carolina General Statute 47F-3-108B, the board shall at regular intervals hold a board meeting. If any uniform and annual assessment or levied assessment is not paid when due, it shall bear delinquency charges established by the board in accordance with North Carolina General Statute 47F. The association may place a lien on any lot or unit or take any such other action prescribed in accordance with North Carolina General Statute 47F to collect any unpaid delinquency charge or assessment. The association shall indemnify and maintain liability insurance for its officers, directors, employees, and agents consistent with the provisions of the North Carolina Planned Community Act, North Carolina General Statute 47F, Exhibit 4, pages 9, 11, 13, 17, and 19. And then North Carolina General Statute Section 47F-3-103, Executive Board members and officers, states, notwithstanding any provision of the declaration or bylaws to the contrary, the lot owners, by a majority vote of all persons present and entitled to vote at any meeting of the lot owners at which a quorum is present, may remove any member of the executive board with or without cause other than a member appointed by a declarant. The charter and bylaws of an association constitute a contract between the organization and its members when the members are deemed to have consented to the reasonable regulations and rules of the organization. Reasonable. Keyword. Traditional rules of contract interpretation apply when assessing whether the association followed its own internal rules and procedures. Master versus Country Club of Landfall, there's another lawsuit referenced here. Because bylaws of a voluntary association are treated as a contract between the entity and its members, the court must foresee the unambiguous terms of the bylaws as written. If the contract is clearly expressed, it must be enforced as it is written. Again, there are a couple of other, for those listening, not seeing, there are a couple of other things referenced here. It is a central principle of contract interpretation that the various terms of a contract are to be harmoniously construed so that every provision is given effect if possible. Wake Med versus Surgical Care Affiliates, another lawsuit referenced, bylaw drafters can choose to restrict some powers of the board while leaving others unfettered. Observing this distinction allows a harmonious reading of the bylaws as a whole that better effectuates the intent of the drafters. Thus, the express invocation of the Unit Ownership Act in the Master Declaration, along with the plain and express language by the bylaws, the latter of which repeatedly referenced Section 47F, generally and without limitation, brought Section 47F and its removal requirements under 47F-3-103 squarely into the association's bylaws and procedures as a matter of basic contract interpretation. The association may not incorporate in its governing documents and utilize North Carolina General Statute Section 47F in practice, which is a similar act regarding unit ownership of property, and then later argue that it is not bound by the provisions of North Carolina General Statute Section 47F. The association is estopped from taking such inconsistent and self-serving positions. I want to be like, Again, as EDB says, allegations and shade. But that's how I want to react to that last sentence. The board's action was invalid due to lack of proper notice. Even assuming arguendo, the board of directors did have the authority to amend the bylaws to increase the vote required to remove a director. They failed to validly take such action on June 28, 2024, due to a lack of proper notice and lack of waiver of proper notice. Resolution 2024-03 states that the amendments of the bylaws by the Board of Directors was effectuated pursuant to Article 9 of the bylaws. Counsel for the defendant asserted that the lack of notice was waived pursuant to North Carolina General Statute Section 55A-8-23. Counsel for the defendant wrote, so this is counsel, likely Hope Carmichael, wrote on behalf of the board. The association does not dispute that the amendment in question was raised by the motion at the board's June 28, 2024 meeting. The failure to provide notice of the potential amendment does not, however, invalidate the amendment. Directors' acceptance at or participation in a meeting waives any required notice to him of the meeting unless the director at the meeting at the beginning of the meeting or promptly upon his arrival objects to holding the meeting or transacting business at the meeting and does not thereafter vote or assent to action taken at the meeting. As stated above, and as admitted by counsel for the defendant, 5 days written notice was not given under Section 55A-10-20 and 21. The meeting's agenda did not include this amendment to the bylaws, thus the objecting directors could not object to holding the meeting or transacting business at the beginning of the meeting, as nothing objectionable occurred until the meeting was underway. So again, having this amendment to the bylaws was not part of the agenda, so there's no way for the board of directors in attendance to have made known at the beginning of the meeting or swiftly thereafter their attendants know that there was anything to object to if there was no contemplation of this being brought up throughout the meeting. You know what I'm saying? I mean, I'm just not going to go to this meeting today because I think somebody's going to talk about something that I don't want to talk about. I mean, we can't operate that way. So anyway, that is a side note. Moreover, the meeting minutes state that 2 directors opposed the motion to add the bylaw change to the end of the agenda. The 2 directors then persisted in their objection by voting against the amendment. In other words, they did not thereafter vote for or assent to the amendment. North Carolina General Statute 55A-8-23B. Due to the Board of Directors' failure to follow proper procedure and to give legally sufficient notice concerning the proposed vote and amendment of the bylaws, the directors' vote and purported amendment are ultra vires, beyond the powers, right? Acts of the association and were void ab initio. void from the beginning. So first claim for relief, ultra vires, I'm going to have to figure out how to say that. Beyond the powers, okay? So beyond the powers, corporate acts preliminary injunction. Plaintiffs hereby re-allege and incorporate herein by reference each of the allegations set forth in the paragraphs above and below as fully set forth herein. Under North Carolina General Statute Section 55A-3-04B, a corporation's power to act may be challenged either 1. in a proceeding by a member against the corporation to enjoin the act, or 2. in a proceeding by the corporation, whether directly or derivatively, against an incumbent or former director, officer, or agent of the incorporation. As set forth, the board of directors of the association failed to follow the proper procedures set forth in the bylaws, and it violated applicable provisions of chapters 55A and 47F of the North Carolina General Statutes in seeking to amend the bylaws. In addition, the board of directors' actions were invalid for failing to provide proper notice to the board of directors regarding the vote, which was not waived. No notice of this proposed amendment to the bylaws was provided. In advance of the meeting of June 28, 2024, and the item was not listed on the agenda. Plaintiffs have been injured in that their majority vote to remove 4 directors in September 2024 was deemed to have failed because the vote for removal did not reach a supermajority of 67%. Further, plaintiffs have been injured and are suffering an ongoing injury in that a contractual provision of the bylaws was changed unlawfully and to their detriment, requiring them to meet higher voting requirements in the event that they wish to remove a director. The purported amendment of the bylaws altered the requirement for participation in the government and affairs of the association applicable to the members of the association. A permanent mandatory injunction should be entered requiring defendant to announce to the members that 1. the board vote held to amend the bylaws on June 28th was ultra vires and void ab initio, so beyond the powers and void from the beginning. 2. the purported amendment of the bylaws was ultra vires and void ab initio, the 2020 bylaws still apply to the operation and governance of the association with full force and effect, and that the majority vote to remove the 4 directors in September 2024 passed. Hey, we've got some people watching. That's amazing. So we are getting some comments. Drops Family Garden, is this an LLC, C, or S Corp? Great question. I do not have that off the top of my head, but I have it somewhere. So we can find that, and I'll add it to the comments of this video once we post it, once we stop the live stream. All right, thanks. Okay, so the injunction should also contain such provisions as necessary to remove or cancel the ultra vires amendments of the bylaws of record with the Register of Deeds and Secretary of State and restore the 2020 bylaws. The injunction should further require that all purported actions taken by the board of directors or the association pursuant to purported authority contained in the ultra vires amendment beyond the power amended bylaws to include the board's determination that the 52.3% vote to remove the 4 directors or any of their replacements for the remaining portions of any term without cause in September of 2024 did not pass, be declared null and void for lack of authority, and that said director so voted for removal be immediately removed as such vote did in fact pass under the majority requirement in the proper bylaws, and that any purported actions, decisions, and or votes by any of the 4 directors or replacements that were voted for removal are null and void for lack of authority. This injunction is necessary to restore the status quo, which was in effect prior to June 2024, and to prevent further and ongoing harm to the plaintiff. Plaintiffs have demonstrated a reasonable likelihood that they will prevail on the merits of their case and that the irreparable harm will occur if an injunction is not granted. There exists a reasonable apprehension of irreparable loss to plaintiffs with respect to the fact that the directors they voted to remove in September 2024 have not been removed according to their majority vote, and an injunction is reasonably necessary to protect the rights of their plaintiffs. There exists a reasonable apprehension of irreparable loss to the plaintiffs with respect to their ability to remove directors that may not be acting in the best interests of the association, or for which other cause may exist for their removal, and an injunction is reasonably necessary to protect the rights of the plaintiff. Moreover, the removed directors cannot be allowed to purport to act as the board members for the corporation when in fact they have no such authority to do so. Proper replacements must be put in place pursuant to the applicable laws and governing documents. The corporation cannot be allowed to be run by those without legal authority to do so. Plaintiffs move pursuant to Rule 65 of the North Carolina Rules of Civil Procedure and North Carolina General Statute, Section 55A-3-04, that this court, after giving of due notice and an opportunity to be heard to the defendant, enter a preliminary mandatory injunction as outlined above. Plaintiffs further request that this preliminary injunction be converted to a permanent injunction upon a final determination in favor of the plaintiffs in this matter. Fairfield Harbour is a planned community under North Carolina General Statute Section 47F, created in this state before January 1st, 1999, and accordingly Section 47F-3-120 declaration limits on attorney's fees applies. North Carolina General Statutes 47F-1-102, see Exhibit 1, page 18. And plaintiffs seek an award of damages in excess of $25,000, as well as an award of an attorney fees under North Carolina General Statute Section 55A-3-04 and 47F-3-120, and or as otherwise permitted by law. Second claim for relief, declaratory judgment action. Plaintiffs hereby re-allege and incorporate herein by reference each of the allegations set forth in the paragraphs above and below as if fully set forth herein. Plaintiffs bring this declaratory judgment action pursuant to the Uniform Declaratory Judgment Act as set forth in North Carolina General Statute Section 125, Section 1-253, and under the provisions of Section 1, Article 26 of the North Carolina General Statutes, for the purposes of obtaining from the court a judgment and declaration with respect to the validity of certain acts of the Board of Directors in light of language contained in the bylaws of Fairfield Harbour, as well as mandates of Chapters 55A and 47F of the North Carolina General Statutes. Plaintiffs have joined in this action all ascertainable parties who may be affected by the declaration. Upon information and belief, there exist no other parties who are necessary to conduct the action, necessary to the conduct of this action. An actual justiciable controversy exists, and thus relief in the form of a declaratory judgment is proper. Plaintiffs contend that the Board of Directors unlawfully purported to amend the bylaws by the board vote of June 28, 2024. Plaintiffs further contend that the Board of Directors failed to comply with the language of the bylaws and violated applicable provisions of Chapters 55A and 47F in their purported amendments of the bylaws. Plaintiffs further contend that the Board of Directors failed to provide legally sufficient notice of this motion and vote with respect to content and timing. Upon information and belief, the Board of Directors failed to properly amend the bylaws in other ways which will be proven at trial. Plaintiffs contend that the purported amendments reflected are ultra vires acts and of the association and are therefore void ab initio. Upon information and belief, the Board of Directors contends that all amendments of the bylaws were proper and that the actions taken thereto are valid and lawful. Plaintiffs have been damaged by the acts of the Board of Directors in purportedly amending the bylaws of the association without proper authority and in violation of North Carolina law. Pursuant to North Carolina General Statute Section 1-254, plaintiffs request that this court invoke its jurisdiction under the Declaratory Judgment Act to construe the bylaws of Fairfield Harbour Property Owners Association, as well as the provisions of Chapters 55A and 47F relating to amendment in order to determine the validity and purported amendments of sufficiency of the notice and the validity of all subsequent actions taken pursuant to the purported authority contained in Exhibit 6, and specifically its failure to remove the 4 directors, Pendleton, Albertini, Brody, and Pfeffercorn, and or their replacements. In this case, Debbie Harris replaced Gail Albertini, and Larry Bladeson replaced David Pfeffercorn, that a majority of the association voted to remove in September of 2024. Plaintiffs further request that the court issue a declaratory judgment declaring the amendment to the bylaws requiring a supermajority vote to be void ab initio, void from the beginning, and striking it from the record, and further reversing or declaring null and void all subsequent actions taken pursuant to the purported amendment to the bylaws, and declare the majority vote for removal of the 4 members of the board of directors on or about September 24th, 2024 was sufficient for their removal, and that as of September 24, 2024, said 4 directors were removed as board members. In the event that a declaratory judgment is entered, plaintiffs pray into this court pursuant to North Carolina General Statute Section 1-259 for such supplemental relief as is necessary to put the declaration into effect, including but not limited to striking and canceling the amendment bylaws and resolutions of record and restoring the previous bylaws that were in effect prior to June 28, 2024, Fairfield Harbour and its planned community center, North Carolina General Statute Section 47F, created in the state before January 1st, 1999, and in accordingly Section 47F-3-120, Declaration of Limits on Attorney's Fees applies, North Carolina General Statute 47F-1-102. Pursuant to authority contained in North Carolina General Statute Section 55A-3-04 and or 47F-3-120, plaintiffs request reimbursement for all attorney's fees spent in order to obtain this declaration, injunction, and supplemental relief. Motion for a preliminary judgment. Plaintiffs hereby reallege and incorporate herein by reference each of the allegations set forth in the paragraphs above and below as if fully set forth herein. A preliminary injunction is reasonably necessary to protect plaintiffs' rights. Plaintiffs' rights to relief is clear, and plaintiffs have demonstrated a substantial likelihood of success on the merits as set forth above. Plaintiffs will suffer irreparable harm if the injunction is not granted. Plaintiffs continue to suffer ongoing harm with each day that the current board members remain on the board and continue to have and exert the power to make decisions affecting plaintiffs' rights and property. Plaintiffs request that the court enjoin the 4 directors or their replacements who the members voted by a majority to remove, currently identified as Les Pendleton, Debbie Harris, Robert Brody, and Larry Bladeson, from taking any action as members of the board of directors now and for the duration of pending litigation. Failure to enjoin the acts to said directors during the pendency of this action will expose the corporation to ongoing actions taken without proper authority. Jury demand. Plaintiffs hereby demand a trial by jury on all issues so trialable. Wherefore, plaintiffs respectfully pray into the court for the following relief: that plaintiffs recover actual damages the defendant, where allowed by law, in excess of $25,000, and that to the court determine the acts of the board of directors in amending the bylaws on or about June 28, 2024 were ultra vires, beyond their powers, and void ab initio, void from the beginning, under Section 55A-3-04, and issue injunctive relief necessary to restore the status quo in effect prior to June 28, 2024 vote and amendment. that the court enter a declaratory judgment finding that the purported amendment of the bylaws are ultra vires and void ab initio, and any subsequent actions taken pursuant to the purported authority of the amended and restated bylaws to include the failure to remove the 4 directors that the plaintiffs and members voted by majority to remove in September 2024 and will be void ab initio, and that any purported actions, decisions, and or votes by any of the 4 directors or replacements that were voted for removal are null and void for lack of authority and will be void ab initio, and that the court enter such supplemental relief as is necessary to put the declaration into effect to include removal of directors Les Pendleton, Debbie Harris, Robert Brody, and Larry Blaisdon, to strike the amended bylaws and resolution 2024-03, and to restore the previous version of the bylaws of Fairfield Harbour to the 2020 bylaws, Exhibit 4. And that the court enter a preliminary injunction enjoining the 4 directors of Fairfield Harbour Property Owners Association, Inc., or their replacements currently identified as Les Pendleton, Debbie Harris, Robert Brody, and Larry Blaisdon from taking any action whatsoever as members of the boards of director now and for the duration of the pending litigation. The plaintiffs recover attorney's fees of defendant under North Carolina General Statute Section 55A-3-04 and or 47F-3-120 and or in the discretion of the court, and that the plaintiffs have a trial by jury on all issues so trialable, and that the cost of this action be taxed against the defendant, and for such further and other relief as this court deems just and proper. The 7th day of February, 2025. And that is the end of this very lengthy lawsuit. Again, this was filed, it looks like it was dated February 7th. It was logged to the clerk's office on February 9th, and we got notice of it today on February the 12th. I read that email earlier in this live stream. So with that, I am not going to, so this is page 32. This entire document is 92 pages with all of the verifications and then all of the different exhibits for our bylaws and declarations from 1979 to today. So I'm not going to go through all of these. There are a few key pieces that I will pull out that I do think are important. And I do see the questions, but I will answer them in the comment section as we upload this video retroactively. So thank you so much for those that were able to listen. For those that do not have time to read all of these, I hope that you're at least in the car while you're at work, maybe you're working out, be able to listen to this so that you understand what's in the lawsuit. That is important. So for those of us like myself, we are a member of this community. We live here. We own properties here. Some of us own one, some of us own more than one. We, being members of the Property Owners Association, we are part of the defense, right? The defendants, the Property Owners Association. But of the 74 members that are suing the Property Owners Association, I certainly understand. I am right there with you. So I mean, again, I will speak in subtitles via my face. But I hope you have a wonderful rest of your day, and we will continue to report out on this, especially for those community members that are able to vote, that own properties here. They're in good standing, but they do not live here full time. Maybe this is a vacation home for them, or they have rental properties here. It's important for you to know as well, because I feel sure that this is going to impact property values. It's going to impact future votes that we have to take on behalf of our board, just to make sure that we have the right folks in office that make the right decisions, or the decisions that we want to have made on behalf of properties here in Eastern North Carolina that are pursuant to the bylaws. So with that, I am going to let you go. I hope you have a wonderful rest of your day, a wonderful rest of your week, and we will talk soon. Have a good night. Bye.